今天，在美国最高法院关于学校里要不要放 LGBTQ+ 书籍的议题吵得沸沸扬扬，而与此同时，川普政府也开始动作，针对反基督教歧视下了重手。首先，川普总统指示成立一个特别小组，叫做消除反基督教歧视任务小组。这是为了确保联邦政府机构不会对基督徒有不公平的对待或政策歧视。这个任务小组由司法部长潘邦迪带头，还有一些川普内阁成员也参加了首次会议。可以看出，川普政府非常重视基督徒的权益。
Thank you all for joining us today. We're excited to be here for the launch of the task force to eradicate anti-Christian bias as outlined in the President's executive order.Joining me today are members of the task force and individuals who have been impacted by the anti-Christian bias. Together, this task force will identify any unlawful anti-Christian policies, practices, or conduct across the government, seek input from the faith-based organizations and state governments to end anti-Christian bias.Find and fix deficiencies in existing and regulatory practices that might contribute to the anti-Christian bias. As President Trump has stated, the Biden administration engaged in an egregious pattern of targeting peaceful Christians while ignoring violent anti-Christian offenses. The President is right. Biden's Department of Justice abused and targeted Christians.Pro-life Christians were arrested and imprisoned for peacefully praying outside abortion clinics. The FBI spied on traditional Catholics in their parishes. President Biden declared Easter Sunday to be Transgender Day of Visibility. No longer. Vandalism against churches was 8 times higher in 2023 than it was in 2018. And it's at President Trump's directive,We ended those abuses at the Department of Justice on day one. We dropped 3 ongoing cases against pro-lifers and redefined the FACE Act to ensure that abuse would not continue and that American tax dollars were not used to support the weaponization of our legal system to target Christians. Just a few weeks ago, we convicted a man in Arizona for a plot to bomb Christian churches. The Department of Justice will protect religious liberty,for Christians and for all Americans. We'll work closely with everyone around this table and take a whole-of-government approach to solving this problem and ultimately protect Americans' First Amendment rights. The First Amendment isn't just a line in the Constitution. It's the cornerstone of our American liberty. It guarantees every citizen the right to speak freely, worship freely, and live according to their conscience without government interference. Protecting Christians from bias is not favoritism. It's upholding the rule of law and fulfilling the constitutional promise. Thank you to President Trump. We have an incredible opportunity, all of us around this table, to protect the rights of all citizens from discrimination based on their religious beliefs.And thank you all for being here based on this executive order, and I look forward to doing great work together. Now, Deputy Attorney General Todd Blanche has a few words.
Good afternoon, everybody. First, thanks everybody for coming, and for members of the task force for being here today and for your commitment to this important effort. If you look around this table, the leadership that's here, I know that combined with our shared determination to establish sound, effective policies and to push back against any form of anti-Christian or anti-religious bias that has taken root within the federal government, this will allow us to carry out the President's executive order. I want to echo what Attorney General Bondi just said. Supporting the free expression of faith is not just a constitutional principle. It is something that all forms of civil government should be encouraging. At its core, the executive order we're here to talk about today affirms a fundamental truth. Every individual has the freedom to choose their religious faith. And once made, that choice should never be subject to discrimination or bias from our government. Now, unfortunately, over the past several years, we've seen troubling signs to the contrary. we have witnessed actions that suggest an underlying bias against people of faith, particularly Christians. This task force was created to make sure this never happens again in America. We will investigate what went wrong, uncover facts, and ultimately chart a path forward. So today, we're going to hear from individuals who will share their personal stories that reflect broader trends and challenges from the Biden administration's policies that, frankly, strip people of their inalienable rights. We're also going to hear from members of this task force about the ways in which anti-Christian sentiment may have shown up in their departments or their agencies. A key challenge that we face is a public misunderstanding of our form of government. We're a constitutional republic, not a pure democracy. And this distinction matters because in a republic, individual rights are protected even when unpopular. And misunderstanding this distinction allows our institutions and media to misrepresent our founding principles. Our government's purpose is to secure rights, not restrict them. So, yes, this task force has a big job ahead, but it's a vital one, and it's one that we're going to get done. Finally, I want to thank the members of the media who are with us today. We appreciate your attention and your presence for this opening portion of the meeting. At this time, we'll be moving into our internal discussions, and so if you would please make your way out, we'll then continue with the rest of our work in a closed session. Thank you very much.
另一方面，美国最高法院也正在审理一件备受瞩目的案子——马哈穆德诉 Taylor 案。这个案子跟学校里该不该放与 LGBTQ+ 相关的书籍有关，像是有些书谈同志婚姻，有些书介绍跨性别角色。争议点在于这些内容适不适合出现在小朋友的课堂上，以及是否侵犯了家长的权利或学生的信仰自由。在法庭上，多位大法官对律师们提出尖锐提问。保守派大法官布雷特·卡瓦诺 Brett Kavanaugh 说他搞不懂为什么这些书不能过滤一下。提问律师，我不理解为什么这样做行不通。
I'm not understanding why it's not feasible. The county had an opt-out, you said. Every other school board in the country has opt-outs for all sorts of things. The county has opt-outs for all sorts of things. The other Maryland counties have opt-outs for all sorts of things. And yet for this one thing, they changed in mid-year and say no more opt-outs. I'm just not understanding feasibility.
So again, I think what's in the record is that with respect to these books as they were deployed in the classroom, there was high absenteeism in some schools. For example, dozens of students being opted out in, I think Mr. Baxter said the average size of an elementary school in Montgomery County is 700 students. So each grade is 125. If you have dozens of students walking out, making arrangements for those students to have adequate space and supervision and alternative instruction, I think is infeasible.
But then they do it for all sorts of other opt-outs.
They don't do it for all sorts of other opt-outs. There's a limited universe of things that students can opt out from. The Family Life and Healthy Sexuality curriculum stands alone. It is mandated by the state. It is something where you are able to predict precisely when the curriculum is going to be deployed. There's a
It's the most similar substantively to what we have here, and there's an opt-out allowed there. I guess I'm not understanding why Montgomery County School Board stands alone. I think in the country, you can tell me if there's another school board that's done something like this.
I apologize.
Both the kind of books that are being used and prohibiting opt-outs. And I guess I'm just not understanding. The whole goal, I think, of some of our religion precedents is to look for the win-win, to look for the situation where you can respect the religious beliefs and accommodate the religious beliefs while the state or city or whatever it may be can pursue its goals. And here, they're not asking you to change what's taught in the classroom. They're not asking you to change that at all. A lot of the rhetoric suggests that they might have, that they were trying to do that, but that's not what they're trying to do. They're only seeking to be able to walk out so that they don't have to, the parents don't have their children exposed to these things that are contrary to their own beliefs.
I understand, Your Honor, and there may well be circumstances where a school can, or a school district can engineer the win-win. Montgomery County schools try to accomplish an educational goal of introducing these books for a particular purpose. They then attempted to accommodate religious opt-outs in the school, and they weren't able.
另一位保守派大法官艾米·康尼·巴雷特 Amy Coney Barrett 则提出假设，如果老师是跨性别的，学生不想用他喜欢的代名词，那怎么办？
Ms. Harris, so there's a lot of concern about line drawing and what this would mean, and maybe some of that would be handled under strict scrutiny or under Smith. I mean, it's not saying that anybody wins or loses if we're just talking about initial steps. But to the point of line drawing, is there a way, let's imagine that the court decided that there was a burden here, that a free exercise right was triggered, that the government thinks we should be careful about to not implicate other things. I'm thinking about, what if a teacher was transgender and the student was very respectful to the teacher but didn't want to use the pronouns, and the parents didn't want the child to use the pronouns, let's say, call the teacher Mr., when she was transgender, when the teacher was transgender. Same for a student in the classroom. Those might present different issues that would be more difficult. So is there something that the government has in mind that would be some limiting principle?
Yes, so just to take the limiting principle first and then your pronoun hypothetical second. With respect to the limiting principle on what a burden is, I think this is the easy case because you have parents' religious obligations and the obligations encompass being exposed to material, and it's just an outright prohibition. But I think Professor Gorgas's article is actually a very good guide to different kinds of burdens that might arise in this context or others that wouldn't qualify. So take the hypothetical of parents want to opt out from school for a month to take their kids on a religious pilgrimage. If your faith is indifferent to doing so in September versus during spring break or summer recess, you don't have a burden on your religious exercise because you have equally available alternative means of doing your religious exercise that don't require the opt-out and don't really put you to the choice that we're talking about. So when you're thinking about things that aren't sort of the prohibition on exposure things, I think there are real teeth in this doctrine, and there's a lot of hypotheticals that you can think of in the school context that would implicate that. With respect to your pronouns hypothetical, I actually think that's a case that raises even more concerns in the sense that you also have, and this is what the Court of Appeals cases bear out, potential compelled speech concerns with respect to you are requiring everyone else in the classroom, first of all, free exercise issues, but also compelled speech issues, to refer to a particular person by pronouns. That's how the cases are kind of getting litigated out in the lower courts right now.
Thank you.
而保守派大法官塞缪尔·阿利托 （Samuel Alito） 则问了一个更实际的问题：这些书是给几岁的小孩看的？
You've made a very broad argument here at times, and it might be good, it might not be good, but let's focus on what's actually at issue in this particular case. What are the ages of the children who are involved here?
These books were approved for pre-K, which in Montgomery County can start as early as 3 if they're going to turn 4 that fall.
And it goes up to what?
The books that we've all talked about go through grade 6.
All right, so you're talking about children maybe in the age of 5 to 11 or 4 to 11. Now, would you agree that at a certain age, students are capable of understanding this point, which probably is not a point that can be understood by a 4 or 5-year-old, and that is that my teacher, who was generally telling me that certain things are right and that certain things are wrong, isn't necessarily going to be correct on everything. It is possible for me to disagree with him or her on certain subjects. Would you agree that there comes a point when a student is able to make that distinction?
That's right, and many of our clients' objections would be diminished as their children got older. But here we're in a situation where Montgomery County's own principals objected that these books were inappropriate for the age, that they were dismissive of religion and shaming toward children who disagree. The board itself withdrew 2 of the books for what it said were content concerns because it finally agreed that what parents and its own principals were saying was accurate.
Yeah, and one final factor that may distinguish this particular case from some of the others that you have been asked to express a view about, and you did touch on this, is the fact that it concerns sex and gender, and that the Maryland legislature itself has recognized these subjects raise special concerns and has provided for an opt-out from the health classes where these matters are discussed.
That's right, and currently in Montgomery County you can opt out from the very same instruction during health class, but then you're required to stay during story time.
Thank you.
值得注意的是，就连长期沉默寡言的克拉伦斯·汤马斯 （Clarence Thomas） 也进行了罕见提问。
Ms. Harris, is there any daylight between your argument and petitioner's argument?
Only as a matter of emphasis. I think they're making a more varied range of arguments with respect to sort of parental rights as potentially a separate strain. Here, I think we all agree that certainly one framework, and the framework we're advocating for, is to view this as putting a price on a public benefit of public education at the expense of forgoing your religious beliefs. Petitioners agree with that, and we agree with petitioners that the fact that there is a long history of parents controlling the religious upbringing of their children in the school context is, if anything, just illustrates exactly why there's an obvious burden here.
What role does Yoder play in your analysis?
Yoder is a textbook example of parents being forced to choose between paying a price, which is having to face severe sanctions, potential sanctions for not sending their children to school, or being able to exercise their faith by preserving their children, their teenagers, from being exposed to worldly influences. And again, that was contrary to the Amish faith, which prescribed that at ages 14 and older, that's the critical time for children to be closer to home and not be exposed to the worldly influences of high school. So I think we're on all fours with Yoder. If the idea that we're just talking about mere exposure here that is not something that would be cognizable just sort of runs flat in the face of that decision.
最后，自由派大法官索尼娅·索托马约 （Sonia Sotomayor） 则拿出一本名叫《舅舅鲍比的婚礼》的书来问问题。这本书是介绍同志婚姻的童书，它气势汹汹，甚至一度训斥律师。你可不可以正面回答我的问题？
Counsel, a couple of questions to clarify things. Uncle Bob's wedding, the child character, wasn't objecting to same-sex marriage. She was objecting to the fact that marriage would take her uncle away from spending more time with her, correct?
Again, it would be, courts would be engaged in religious discrimination.
I'm asking you to answer my question. It wasn't that she was objecting to gay marriage, qua-gay marriage, period. She was objecting to having her uncle's time taken by someone else.
I'm not sure that's correct, Your Honor. I think for a child of that age, it's hard to express what their actual concerns are.
Well, when the character says, he'll have less time for me, it seems self-evident, isn't it?
Your Honor, again, Montgomery County's own principles.
All right, now let's go back to this question of age, okay? And what teachers are saying or not saying. Do you want a special rule for children between kindergarten and 6th grade?
Well, if the court wanted to go there, that certainly would make common sense. Parents everywhere know that children are especially vulnerable
Where in
and
our
exposed.
case law would you see that as just mere age is coercion, exposure is mere coercion of a certain age?
Well, this court has frequently recognized that, for example, children lack the maturity to make decisions, to discern sometimes between truth and error, to weigh what their parents are saying versus what their teachers are saying.
So if some of this objection, you said you don't have an objection to showing an interracial marriage, you don't have an objection, qua-objection, to merely gay couples shown to marrying, as long as you don't have approval of that? Is that what you would object to?
Well, Your Honor, again, it would depend on the individual's beliefs. And this court has already held, for example, in Bob
So
Jones,
if none of all of
burden.
the parents, many of the affidavits that the parents put here said they don't mind teaching respect and kindness towards people who are different. The objections appear to be with some of the teacher instructions, the ones having to do with altering the mindset of children, or the ones talking about gender being a guess at birth. Those were the things that I saw the parents objecting to.
The parents object to the books and to the instructions. There's no question that together, and even separately, the books go to indoctrination more than exposure.
We can look to the record for that, correct?
I'm sorry?
We can look to the record for
That's correct.
整体看起来，对于这个案子，最高法院的9位法官大致分成了4种不同的阵营。自由派法官组成了第一阵营，他们担心划界线太难。3位自由派法官索托马约 （Sonia Sotomayor）、凯根 （Elena Kagan） 和杰克森 （Ketanji Brown Jackson） 都很在意到底怎么划界线才公平。第二阵营则由3位保守派法官构成，他们就是想要替家长撑腰。大法官汤马斯 （Clarence Thomas）、卡瓦诺 （Brett Kavanaugh）、巴雷特 （Amy Coney Barrett） 都在找机会怎么帮这些家长出一口气，也就是想让学校不能随便教这类内容。第三阵营则是保守派的阿利托法官 Samuel Alito 和首席大法官罗伯兹 John Roberts， 他们则特别担心小孩的影响力问题。阿利托认为大一点的学生能分辨老师的话不一定是对的，所以有冲突没关系，但小学生不行，他们会把老师的话当成绝对真理，所以要更小心。第四阵营则是高索奇法官 Neil Gorsuch 单独一人，他倾向于用技术性理由判得更保守，也就是说他走了一个比较技术性的路线，抓住一个细节。原告律师说，有个校董会成员曾经把反对这些 LGBTQ+ 书籍的家长比喻成白人至上主义者和排外主义者。这很重要，因为在2018年的 Masterpiece Cake Shop 案中，法院就因为州政府官员讲了一些不尊重信仰的话，判决偏向一位拒绝为同性伴侣做婚礼蛋糕的基督徒糕点师。所以高索奇的意思可能是，我们可以只针对这个案例判，说因为这位校董讲错话，所以家长赢，但不需要大规模改变所有学校的教学规则。换句话说，就是这次让你过，但下次不一定哦。那么本案的结果会怎样呢？目前来看，这个案子可能有两种走向，一种是法院只针对蒙哥马利郡的家长开个小门，不影响全美学校。另一种是法院会整体上限制学校能教什么，甚至变相推出小学生版的不能说同志法，让老师不敢提到任何同性恋或跨性别相关的东西。